My name is Glenn Chavez, Your Honor.
Mr. Chavez, I have a uh, mailing address for you in Wellston. Is that a good mailing address?
That will do, yes.
And a telephone number ending in 4504, is that a good number?
Yes, that would be my fiance's. I just got a new phone and don't remember mine.
All right. Did you have the opportunity to meet with somebody from the defender's office today?
Yes,
I have a complaint that alleges that on or about January 18th, 2026, in the city of Cadillac of Wexford County, in count number one, it's alleged that you committed the offense of malicious destruction of a building, $200 or more, but less than $1,000. In particular, it looks like something at Munson Hospital. Do you understand those charges and the potential penalties? I'm sorry, that's a 1-year misdemeanor. Do you understand that?
yes,
That also carries with it a $2,000 fine or 3 times the value of the property destroyed. Do you understand that?
I do.
Did you read and sign an advice of rights form at the jail that talked about your rights to an attorney and your rights to a trial?
Yes, I did.
Did you understand those rights?
Mostly, not really.
All right, so I'm going to go through them with you just to make sure you understand them. If you have any questions, let me know, all right?
Thank you, I sure will. Also, Your Honor, I would like to apologize. I would never dress like this in a courtroom. I had no choice, so my apologies.
I understand. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. Do you understand that?
Of course, yes.
You've been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty. If you stand mute, a plea of not guilty will be entered and you may plead no contest with the permission of the court. To have a trial by jury and to have the assistance of an attorney. Do you understand those rights?
Yes, I do.
You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney. And if the offense charged requires a minimum jail sentence, or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. Do you understand that?
That I do, yes. Okay.
You may have to repay a portion of the expense of an appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for the attorney, and the court must determine your ability to pay at that time. Do you understand that?
I do.
If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you, to be a witness for yourself, or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up those trial rights that we just went through. Do you understand that?
I do.
You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. Do you understand that?
Yes.
You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Do you understand that?
Yes.
Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to make payment arrangements. Do you understand that?
Yes.
An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule if the sentence includes incarceration. And if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if that request is made within 14 days after sentencing. Do you understand that?
Yes.
Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver, if you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand that right?
Yes, yes.
Do you have any questions for me about what we just went through?
I guess this misdemeanor is a violent misdemeanor. Would that count? The destruction of property?
It is not considered a violent misdemeanor.
Okay, that was my only question.
All right. So you do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. So my question to you is, do you wish to hire an attorney, represent yourself, or request the appointment of an attorney?
I'll request the appointment of an attorney.
All right. The court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial or work out some sort of plea agreement. Does that make sense?
Yes.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I do not show any convictions. The praxis scores him at a risk level 1. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. Especially with no priors and a low praxis score, I'd ask the court to consider a personal recognizance bond. He's informed me he's a stay-at-home dad, so he doesn't have a whole lot of income. He's not from our immediate area, but he is from the state of Michigan. He has every desire to, if given a personal recognizance bond, go home, be with his 2 kids. He would obey any bond conditions we place on him, any non-monetary bond conditions. I do believe this would be an appropriate situation for that. If the court wanted any no contact orders, things of that nature, we of course respect the court's discretion, but again, I do believe PR is appropriate. I'd ask the court to do so. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. Usually in a case like this, I would not oppose a PR bond, but I am going to, and I would ask the court to set a monetary bond. It is alleged in here that the defendant was in the emergency room for an attempted suicide. When staff had told him that he was going to a mental health facility, he began punching holes in the wall. Mental condition, I believe, is a bond factor, and I think the court should seriously take that into consideration here. I think there are some concerns, not only safety, but the defendant's safety of himself. So I would ask the court to set some type of monetary bond. I'm not opposed to a PR bond with immediate release of treatment. If that's something that could get set up, it does sound like the hospital staff did have something lined up. So I would ask the court to set at least some type of bond in this case. Thank you.
Your Honor, may I speak for myself for a moment?
So I don't want you to say anything about the case, but if you have something you'd like me to consider for bond, I'll do that.
I'm afraid I don't understand the difference in that.
So I
request.
don't want you to say anything about the facts of the case or what the allegations are. But if you want me to consider, for example, like a job history or something like that, that you want me to consider when it comes to releasing you, I'll allow you to do that.
Okay. I've nothing to say. Thank you.
Okay. Ms. Lawrence, I realize you probably don't know yet. Do you know, has there been any steps taken for involuntary committal?
I do not know that, Your Honor.
All right. I do know that the court had received a call from the jail that he was working with mental health in the jail. I do find the defendant a risk right now, so I will set bond. Bond was previously set at $500 over the weekend. I'm going to increase that to a $5,000 cash surety bond with the conditions that Mr. Chavez, you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm not going to order no contact with Munson Hospital. I will order, though, that you not purchase or possess any firearms or weapons, and you not act in any threatening, intimidating, harassing behavior. All right.
A question, if I may. Assuming I can't afford that, which I can't, I have to stay in jail until my court date.
So your court-appointed attorney will know the steps that need to be taken if you're not able to post bond. All right?
Okay.
Is that it from jail? Thank you, Jail.
Thank you, Your Honor.
All right, this is case number 26-190 SM. We're here for an arraignment. Mr. Galvanic, did you read and sign this advice of rights form?
Yes,
Did you understand those rights?
yes,
The contact information on the back of that, is that accurate?
yes,
Did you have the opportunity to meet with somebody from the defender's office today?
yes,
I have a complaint that alleges that on or about January 16th, 2026, in the city of Cadillac, Wexford County, it is alleged in count number 1 that you committed an act of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense. So you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I plan to represent myself.
So before you can do that, I had to be convinced that your waiver of an attorney is knowing and voluntary. All right, so I've got a form here I'm gonna read to you. But before we do that, how many years of education do you have?
12,
Graduated high school?
yes,
All right, this says, I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime and have read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I have the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. That the risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection procedure or how to preserve my appeal rights. That because of these things, it can be unwise for me to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. I have 12 years of education. I read and understand the English language, and I am mentally sound. Having gone through all that, do you still wish to represent yourself?
yes, sir.
Bailiff? The bailiff is going to have you sign this form that we just went through.
Okay.
So you do have the right to be represented by an attorney at all phases throughout this. So if at any point throughout this process, you decide that you either want to hire an attorney or that you want the court to appoint one, let us know and we'll make the appointment, the referral for the appointment. All right. So today, you have a couple options available to you. One would be to plead guilty. If you pled guilty, the 93-day misdemeanor would enter on your record. I don't know, we probably would not be able to be sentenced today because there's the right for Mr. Galvanic to have victim notification. The other is to plead not guilty. If you pled not guilty, we would set the matter for a pretrial. That would give you the opportunity to discuss the case with the prosecutor to see if there's a way to resolve it, short of going to trial or having you enter a guilty plea. Do you understand those two options?
Yes, sir.
You sure?
Fairly certain.
All right. Today, then, how do you plead? Guilty or not guilty?
Not guilty.
All right, the court will enter a not guilty plea. We'll set the matter for a pretrial, which is that hearing that will give you the opportunity to discuss the case with the prosecutor.
Yes, sir.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. I show a $500 bond was posted over the weekend. You have no prior history. Ms. Lawrence, and the praxis scores you at a risk level 1, which is low risk. Ms. Lawrence, do you have any comment regarding bond?
I do, Your Honor. Our office was able to speak with the victim very briefly. The victim is the defendant's father. He did say he does not wish for a no contact order. The defendant does live with him. He did say that it seems that the underlying problem is likely the defendant's drinking. Drinking was involved in this. The defendant took a PBT that came back at 0.16. When his father tried to take a bottle of alcohol away from him, the defendant began punching and pushing him. So at this point in time, I'm not going to ask the court for a no contact order, but I would ask for no alcohol provision as well as random testing.
Mr. Gravalik, this is where things get a little tricky because I don't want you to say anything about the case yet. But is there anything you would like me to know regarding bond?
Regarding bond, no.
Okay. If I did impose a no contact order with your father, would you have a place to go?
Yeah, it'd be my grandparents. All my stuff's at my house.
Which is where your dad lives?
Yeah, I haven't seen him since it happened. I do understand my drinking has been.
Hold on, I don't want you to say anything. So where have you been staying with your father since you got out of jail?
No, so.
Okay.
So the first night I stayed at my friend Mitchell Smith's house. His mom let me stay there. The second night I ended up sleeping in my car at Walmart parking lot. And then the third night I was able to stay at my friend Mitchell's again.
And you're 22,
21.
21?
Yes,
Are you currently employed?
yes.
Where do you work?
Cadillac Walmart.
All right, I will continue the bond as previously set with the following conditions: that you appear as ordered, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any alcohol, and you'll be subject to random testing. I'm ordering no controlled substances, including recreational marijuana, and random testing for that as well. I don't want you switching one substance for another. It's very rare that I do this, but I will not order a no contact in this case. But you are to not act in any threatening, intimidating, or harassing behavior, and not to purchase or possess any firearms or weapons. If you are found to be in violation of your bond conditions, you can be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that? Do you have any questions for me about your bond?
No, sir.
All right, you'll need to go out to the front window where you checked in, get your next court date, and then you'll need to go downstairs to community corrections and get signed up for your testing.
Okay,
All right?
all righty, thank you.
All right, thank you.